You open the USPTO correspondence portal, or maybe your mailbox, and there it is. A formal letter from an examining attorney citing a specific legal problem, a clock that is already running, and the fear that your trademark application is dead. This explainer covers exactly how to identify the legal problem you are facing, calculate your absolute deadline, and structure a response that prevents abandonment.
Does receiving this letter mean my trademark application has been rejected? That is the immediate fear, right? Well, the short answer is no. An office action is simply a standard step in the examination process. It is absolutely not a final determination on the mark. It just means the examiner found an issue that has to be resolved before the application can move forward.
So how much time do you actually have to respond before your deadline runs out? You definitely cannot just relax. You are on a running clock. Strict deadlines apply the moment that letter is issued. Now, the exact timeline depends on how you filed, but remember this crucial point. The clock starts on the issue date stamped right at the top of the action, not the day you happen to open the portal.
And with that clock running, he must identify exactly what you are dealing with. What is the difference between the kind of office action you can fix yourself and the kind that needs a real legal argument? We divide these actions into two distinct categories. First, we have simple procedural errors. These are minor, straightforward corrections to the application itself. Second, there are complex, substantive legal refusals. These are serious roadblocks requiring a highly structured legal defense.
What happens if you miss the deadline? Do you lose your filing fees and your place in line? Yes, unfortunately you do. If you miss this deadline, the consequences are severe. The USPTO does not pause your application. It abandons it outright. You forfeit your non-refundable filing fees entirely. You erase your original priority date. To try again, you literally start over at the very back of the line.
Now, international applicants face a very unique scenario. You might be asking, my application was filed through the Madrid Protocol. Does the normal deadline even apply to me? If you filed through the Madrid Protocol, the normal deadline rules do not apply to you at all. Madrid Protocol filings operate under a completely different, highly rigid timeline structure. We will break down exactly what that means for your calendar shortly.
Finally, what actually makes a response strong enough to work versus one that just restates your case? A successful response does not just tell the examiner they are wrong. You must persuade them using specific evidence, and that evidence must be tied directly to their own stated reasoning. You really have to play by their rules.
To put this whole situation into perspective, let us look at the numbers. Speaking from direct examiner side experience, having seen this exact letter arrive in 100 inboxes before, we can tell you that roughly 30 to 40% of all trademark applications receive at least one office action during examination. It is a highly routine procedure. It is not a sign of a doomed filing. It is just the standard reality of the trademark registration process.
As we mentioned, these issues fall strictly into two camps. On one side, we have procedural issues. These ask for straightforward corrections, like an updated specimen showing use in commerce. On the other side are substantive refusals. These refused registration on strict legal grounds under Section 2 of the Federal Lanham Act, which is the statute governing U.S. trademark law. No simple amendment fixes a substantive refusal. It requires true legal persuasion.
You will typically face one of three common substantive refusals. First is likelihood of confusion under Section 2D. Here, examiners weigh the DuPont factors to evaluate your mark's similarity to an existing registered mark and the potential for consumer confusion. Second is mere descriptiveness under Section 2E1. This evaluates whether your mark merely describes a feature of your goods or services. Third is the Section 6 disclaimer requirement. This means you must formally relinquish exclusive rights to a generic or descriptive portion of a composite mark.
Building a response to these specific refusals requires real precision. If you want the full breakdown of how to structure a response for each specific refusal type, the full article is linked in the first comment below. It walks through the exact legal arguments needed for each scenario.
Let us turn back to that running clock and get specific about your deadline. Following a December 2022 rule change, most pre-registration office actions carry a standard 3-month deadline. You can extend this once for a fee, giving you up to 6 months total. Contrast this sharply with international Madrid Protocol filings under Section 66A. Those receive a strict 6-month deadline with 0 extensions available at all. You absolutely must know which rule applies to your filing.
The path to approval requires precision. Examining attorneys reject generic template arguments on site. A strong response addresses every single ground cited in the office action. It amends what can genuinely be amended. Most importantly, it argues substantive refusals with highly specific evidence. For a likelihood of confusion refusal, you must tie your evidence directly to the DuPont factors. A simple restatement of general trademark law will fail every single time.
The one thing to take away is this. An office action is a problem to solve on a deadline, not a verdict on the mark, and how you respond determines whether the application survives. If you have received a trademark office action and need help evaluating exactly what it is asking for before your deadline runs, the full article walks through every refusal type and deadline in detail, and it is linked in the first comment below. Subscribe if you want this kind of practical examiner-side USPTO guidance without having to go dig for it every time. The clock is already ticking on your application. Are you prepared to answer the examiner's exact legal arguments, or will you let your priority date slip away?